各位好。
Good afternoon, everyone. The Chief Executive will first make a statement before answering questions. When you ask questions, please confine your number of questions to 2. Chief Executive. Yesterday, I received from the Central People's Government, in accordance with Article 11 of the National Security Law, a letter requiring the Chief Executive to, since the promulgation of the National Security Law, to perform my duties to safeguard national security. That include work involved to protect national security. I'm required to submit a report. There is an attachment to the letter with specific instructions. In accordance with that, I convene a meeting of the Committee for Safeguarding National Security of the Hong Kong SAR. In my capacity as the Chief Executive of the Hong Kong SAR and the Chairperson of the Committee for Safeguarding National Security of the Hong Kong SAR, I hereby state that protecting national security, sovereignty, and national development interest is the highest threshold of one country, two systems. Under Article 3 of the National Security Law, we have a constitutional duty to safeguard national security. The executive authorities, legislature, and judiciary of the region shall effectively prevent, suppress, and impose punishment for any act or activity endangering national security in accordance with this law. So in the protection of sovereignty, national development interest, and national security, our stance is unswerving and very clear. It's been over 2 years since the promulgation of the National Security Law. This has made a significant difference to the law and order situation in Hong Kong. We have moved from chaos to stability. Stability has been restored. Now we move further from stability to prosperity. On all fronts, Hong Kong is more safe and secure. I will, in accordance with the requirement of the central authorities, submit a report as soon as possible. There is a case that is of public concern, that is in relation to Mr. Timothy Owen, King's Counsel of the United Kingdom. He has obtained an approval by the Court of Final Appeal, admission to Hong Kong Bar to represent Mr. Jimmy Lai. In a specific case, Mr. Lai has been charged with offenses related to national security. The Secretary for Justice has applied for leave to appeal. This afternoon, the Appeal Committee of the CFA made a determination to dismiss the application of the Secretary for Justice. In a report to be submitted to the central authorities, I will mention this case. I will make a suggestion, a proposal, that the matter be submitted to the NPCSC, and in accordance with Article 65 of the National Security Law to clarify the following matters. In accordance with the legislative intent and objective of the National Security Law, whether a lawyer who is not fully qualified cannot take up work related to national security cases. The considerations for the interpretation of the law includes: 1, the National Security Law is promulgated under the principle of one country, two systems to safeguard national security. It is a national law. The Hong Kong National Security Law targets serious acts that undermine national security. That includes black violence, interference from foreign or external forces. The Central Authority Hong Kong Macau office in 2021 April issued an open letter pointing out that the extradition bill saga in 2019 is a Hong Kong version color revolution. Taking into account the situation in Hong Kong, the NPCSC has been empowered to enact the National Security Law. The National Security Law of Hong Kong overrides local legislation. Article 62 says that the national security law shall prevail where provisions of the local laws of the Hong Kong SAR are inconsistent with this law. National security is of paramount importance. We have to effectively implement the national security law to prevent all risks that would undermine the national security. When it comes to national security, the situation is complex and changing. That includes collusion, conspiracy, provision of funds, and preparation work that would undermine national security. These acts would take place undetected and in advance. These acts may take place outside Hong Kong, and they may materialize before an offense is committed. It's not easy to detect these illegal acts. It is not easy to safeguard national security. We all have the duty to stay vigilant. Foreign or external forces are hostile towards the implementation and promulgation of the national security law. They have on a number of occasions attempted to interfere with the implementation of the law. For different agenda or purpose, they have imposed sanctions and other measures targeting China and the Hong Kong SAR. These measures include sanctions, restrictions, and limitations of sale or use of certain goods. There are also overseas politicians or government officials openly requesting Hong Kong people to boycott Hong Kong personnel or activities. There has been continuous interference from foreign or external forces. We have to step up our vigilance. Article 3, 8, and 42 of the National Security Law require relevant agencies to fulfill their responsibility to effectively prevent acts or activities that may undermine national security. Under the existing system, there is no effective way in the Hong Kong SAR to stop overseas counsel or solicitors to stop conflict of interest, and there is no effective way to stop them from or to prevent them from being subject to dubious interference. There is no effective way for the Hong Kong SAR to make sure that they will keep all state secret, trade secrets, or personal information as required under Article 63. Based on these potential risks, if we allow overseas counsel to participate in national security cases, we would wonder whether it is in line with the legislative objective and intent of the promulgation of the national security law. We Hong Kong residents have the right to choose a lawyer under the Basic Law. By that, it is meant that lawyers who are fully qualified in Hong Kong, but not overseas lawyers who are not fully qualified. So defendants in national security cases cannot hire overseas counsel to represent them. This is in line with Articles 4 and 5 of the National Security Law, that is, the safeguards of freedom and rights of a person. As Chief Executive of the Hong Kong SAR and Chairman of the Committee for Safeguarding National Security of the Hong Kong SAR, in accordance with Articles 11 and 12, am accountable to the central authorities. Based on these considerations, in the report to be submitted to the central authorities, I would propose that these provisions I've mentioned and relevant provisions be subject to interpretation by the National People's Congress Standing Committee. I will submit the report to the central authorities as soon as possible and ask them to deal with it ASAP.
The floor is now open to questions. Before putting your questions, please identify your media outlet. Please limit yourself to 2 questions and use the microphone we provide to you. The first one, the gentleman in the front row. Good evening, Chief Executive. I'm from TVB. In the CFA's judgment today, it said that the Secretary for Justice made a new point in the argument to the CFA only, and there was insufficient argument. Is there any deficiency in the way the DOJ handled the case? Just then the Chief Executive said that without existing provisions, it's hard to ensure that overseas counsel observe the confidentiality provisions. Will this requirement apply to judges from overseas as well? How can we ensure that they can handle state secrets properly? First of all, the Secretary for Justice has done his best in the arguments advanced and has put forward all the arguments that the court should consider. The court has made a decision based on the argument, and I respect the decision. As the Chief Executive and the Chairperson of the Committee for Safeguarding National Security, there's a duty on me to consider when there's a point that requires clarification. Safeguarding national security is of paramount importance. There will be far-reaching implications from this incident, so there's a need to clarify some points. Now, turning to the confidentiality requirement, there is no way for us to eliminate the relevant risks. This is partly why I propose an interpretation from the NPCSC. There is a system in place in appointing judges. For someone to be appointed a judge, there has to be a recommendation and an appointment system. The appointment goes through integrity screening. Under the national security law, there's a system in place regarding designated judges to make sure the national security law is properly implemented. So these are 2 separate matters. Next question. On the left, the lady at the back. I'm from Singtao Daily. First of all, I just want to find out if you're doing well, if you have just recovered from COVID. Now, turning to the question, the Secretary for Justice failed to obtain the leave for appeal. And now, Chief Executive, you are saying that you are proposing to ask for interpretation. Would this create the impression that the government is being a sore loser, that is losing a court case and then asking for an interpretation from the NPCSC? Now, with overseas judges precluded from future national security cases, Mr. Tam Yu Cho mentioned that there has been discussion about the legislative intent, meaning there should be no foreigners involved in national security cases. But the provisions did not say that foreigners should not be included in such cases. Would the interpretation end up going against the legislative intent of the national security law? Thank you for your concern. As you can see, I'm doing okay. I resumed work yesterday. Thank you again for your concern. In the question about an interpretation, as the chief executive and the chairperson of the Committee for Safeguarding National Security, I have a constitutional duty to ensure that national security is safeguarded. And second, I received a letter from the central authorities, so then I convened a meeting of the Committee for Safeguarding National Security. At the meeting, we arrived at a decision. The application from the Secretary for Justice has been rejected. We looked at the justifications, so we decided to propose an interpretation. The third point here, the institutions, our court exercised judicial powers and the power of final adjudication in an independent manner. And as for the power of final interpretation for the basic law and the national security law, the provisions are clear. The power of interpretation rests with the NPCSC. It's a question of national security. I just set out my concerns and my considerations. This case will have far-reaching implications for future cases. So in line with the relevant legal procedure and to uphold the constitutional order, we need the NPCSC to offer an interpretation to clarify the point. This is in line with the interest of Hong Kong and in line with the requirements under the national security law. This is also in line with the constitutional order. So this decision is arrived after careful and due consideration. This is also a decision to safeguard national security. We're targeting a very specific issue, that is overseas counsel. They're not supposed to practice in Hong Kong. So this proposal targets this group of counsel in particular. We're not targeting people by nationality. For counsel already practicing in Hong Kong, they are of different nationalities. Under the existing laws, they can take part in various cases. As for judges, we have a system in place for appointing judges. The judges go through screening. When a judge takes office, there is a swearing in. They make sure the judges uphold the basic law. So there is a system in place. The interpretation would target one specific group of people, and it targets one specific issue. And given the far-reaching implications, we need to sort this out. Next question, the lady in gray.
from RTHK. So you said you would ask Beijing to interpret the law as soon as possible. Do you have a timetable for that? Will this delay the trial because it's starting on Thursday? And my second question is, there are no provisions in the national security law against the use of overseas counsel. So what are the government's objections in this case? Thank you.
I shall submit my report to the Central People's Government very soon, and I would request the Central People's Government also consider my request as soon as possible. For an important and significant matter like this, I think the Central People's Government will pay special attention and regard to the whole matter. I trust that this matter will be addressed as soon as possible. It will be appropriate for the Secretary for Justice to seek an adjournment to the actual trial. And we shall proceed to do that. The questions that I'm seeking the National People's Congress Standing Committee to look into is to examine, based on the legislative intent and purpose of the national security law, can an overseas lawyer or counsel who is not qualified to practice generally in Hong Kong participate by any means in the handling of the work in cases concerning offenses endangering national security? I have given my reasons and considerations in the Chinese version. I will provide you with the English translation later, rather than repeating the whole article. Okay, let me just sum it up for you then, all right? But the full details, you have to refer to the actual text. Well, first of all, the Hong Kong National Security Law is a law enacted to deal with actual situation which occurred in 2019 in Hong Kong, where there was massive violence and disturbances. There was advocacy for Hong Kong independence, and also there is interference by foreign forces into Hong Kong affairs. And the Hong Kong, Macau and Affairs Office has in 2021, in an article which is made public, describing the incident as a Hong Kong version of Color Revolution. And Hong Kong National Security Law was enacted under these circumstances and in this context. The Hong Kong National Security Law, relative to other Hong Kong laws, have an overriding position, which is described in Article 62 of the Hong Kong National Law, which says that if there are incompatibility, then the Hong Kong National Security Law takes precedence. And the risks of national security are serious and varying. And a lot of these risks actually occurred in the planning stage, in the conspiracy stage, in the collusion stage. And if involve collusion with a foreign government, then it's very likely that they occur overseas. So even if they occur well before the actual offense takes place, they may not be easily seen or observed. And it is important that anybody who is involved in work to safeguard national security have regard to this seriously. There have been many incidents of foreign government officials and foreign politicians trying to interfere with Hong Kong affairs, also targeting our country and Hong Kong, making announcements or taking measures to sanction, to prohibit, or stop the use of equipment or items. And there have been incidents in which officials of other country openly interfere with people coming to Hong Kong to perform normal activities, including people in the legal and commercial sectors. At the present, there is no effective means to ensure that a counsel from overseas will not have conflict of interest because of his nationality. And there is also no means to ensure that he has not been coerced, compromised, or in any way controlled by foreign government, associations, or persons. There are also no effective means to ensure that a counsel from overseas will comply with Article 63 of the Hong Kong National Security Law, that during his legal practice, that he will keep secret of information such as state secrets, commercial secrets, or personal details. These underlying threats exist. So it is a question whether allowing overseas counsels who do not have the practice, general practice qualification to carry out legal service, allowing them to take part in national security cases, is it compatible with the legislative intent and purpose of the Hong Kong National Security Law? I also consider that while Hong Kong people have the right to choose their own lawyers, according to stated cases, this means that the defendant can choose amongst all lawyers who can practice in Hong Kong, and not about choosing a lawyer that is from overseas who do not have the right at that time to practice in Hong Kong. So, not allowing counsels in overseas of this kind to come to Hong Kong to represent a defendant is compatible with the Hong Kong National Security Law, Article 4 and Article 5, which safeguards and respects human rights, particularly the rights of the defendant. And it is under all these considerations that I make the recommendation to seek the NPC SC to interpret the Hong Kong national security law to answer that question.
時間關係咧，我哋答埋今日最
We'll take questions from two more reporters. The reporter at the front. I'm from Now TV. In the determination of the CFA, the court said that there was no information in relation to using overseas lawyers and its impact on national security. Well, they only talk about a new point. Does it mean that the Secretary for Justice will have to be held accountable for failure to satisfy the court? And when do you expect the result of the interpretation to be available? In the process of the appeal, from the time when he lodged an appeal to the case being heard by the Court of Final Appeal, he has done his best. He has put together cogent evidence and complete evidence for the submission to the court. And of course, the court will follow their procedure. But in the whole process, the Department of Justice has acted in accordance with the evidence they have. They have fought their corner. And I give my recognition and validation to the work of the Department of Justice. I respect the decision of the court. But as the Chief Executive, as chairperson of the Committee for Safeguarding National Security of the Hong Kong SAR, I have to perform my duty to safeguard national security, which is of paramount importance. I recommend an interpretation to be made by the NPCSC on a number of issues because I think that this is an appropriate decision. So in my report to be submitted to the central authorities, I would make this request. We will take questions from one more reporter, the lady in the middle at the back. I'm from Cable TV. Under the current legal system, Hong Kong people have the right to choose their lawyers, but now these lawyers are confined to those that can practice in Hong Kong. Does it affect their rights? Will it affect Hong Kong's position as a common law jurisdiction in the world? Well, why is it that the Secretary for Justice asked for a blanket ban on admissions of overseas counsels? But there is no such provision in the national security law. Does it mean that you have missed something at the beginning, or it was too rushed to promulgate the national security law? I have actually answered this question, but I will answer again. First of all, Hong Kong residents have the right to choose their lawyers, but according to authority, the right to choose among lawyers who can practice in Hong Kong, but not overseas lawyers who are not qualified to practice here. Secondly, what we are dealing with are overseas counsels, overseas lawyers who can't practice in Hong Kong. You should not apply what I said to too wide a scope. What I'm saying is that we're only talking about overseas lawyers coming from overseas without the right to practice here. For that person to practice in Hong Kong, an application has to be made from the court. So it is only in this regard that we're talking about. So we're not targeting any other categories of persons or any persons who take up legal work, please listen to the question and the information very carefully. And as I've said, there is a very vigorous system put in place in the appointment of judges. So the matter you mentioned is very different from the appointment of overseas judges, because we have a system in place to recommend judges, for them to be vetted, and in the end appointed. So you have to make sure that there is a clear differentiation. What I'm talking about here are lawyers coming from overseas without the right to practice here. That's the end of the press conference. Thank you.